Hi, I'm Susan Lipp, Editor-in-Chief of Trust and Estates, and I'm speaking with Jamie Hopkins, the Chief Wealth Officer at Bryn Mawr Trust. We'll be discussing some of the issues that arise when an ex-spouse is named as the beneficiary of an employer retirement plan or an individual retirement account. And this was the subject of two recent articles by Christopher Hoyt in the June issue of Trust and Estates. So let's get started with our Q&A with Jamie. What's the challenge with estate planning today as it relates to employer-sponsored retirement accounts?
Yeah, it's such a great question. And it's something that's really wasn't in design when you go back to the 1970s as transient as families were going to become in the United States, right? Where divorce became kind of more acceptable and families with stepchildren, adopted children, the world changed. So a lot of our laws and regulations that kind of predate the 1990s really didn't keep up with this. And so the challenge that you see, just very bluntly put, is you see a lot of beneficiary designations out there listing ex-spouses, children from a first marriage, and never getting updated. And this creates a lot of complexity on who gets the assets after somebody dies. And we really do have conflicting state laws with federal laws here, which adds to that challenging component.
Right. And I know when you're dealing with the employer retirement plan, ERISA comes into effect. So what is the ERISA preemption clause and why does it matter for estate planning?
Yeah, it's a great point. And this follows up with that last comment that we have this differing rules. Most states have put something in place that says, look, ex-spouses are just not entitled to your stuff, right? Like that bluntly put, right? You got divorced for a reason. You don't want your ex-spouse to have these assets. But ERISA provides a little bit different. They kind of say, whoever's in the beneficiary designation gets the stuff, right? Gets the retirement account. And it also has something called the preemption clause. The preemption clause that you asked about is really important because what this allows employers to do is understand that they're operating under one ERISA law, not 50 different state laws. But ERISA having that preemption that really whoever is listed as the beneficiary gets the death benefits of the account preempts the state laws that say, hey, ex-spouses don't get this. And so this is where we get that conflict where ERISA says we preempt state law, we're federal law, we're number one. And your ex-spouse, if listed as your beneficiary, will get your death benefits, minus some exceptions, which I think we'll get to.
Mhm. Well, what is the general rule about current spouses and beneficiary designations of employer plans?
Yeah, so the main rule is actually that your spouse, while you're at an employer plan, is entitled to your full death benefits when you pass away, unless they otherwise, right, give essentially some notice that they're okay with you giving it to somebody else. So they have to really opt out of it. So what that means, right, is generally speaking, you get divorced, you get remarried, your current spouse at your date of death is really entitled to the full death benefits of your employer plan. Now, here's where the challenge lies, though, is not really that situation. It's really when we have situations where we don't get remarried, right? Maybe we're dating somebody, maybe we're living with them. In that situation, then the new spouse doesn't come into play. So the ex-spouse is left on the account and all of a sudden becomes entitled to that money because we don't have a new spouse that kind of kicks in here. And that's really the challenge you see. You see a lot of senior individuals, especially today. Senior divorce has gotten really big. The gray divorce is a really big thing. And even if they start dating somebody, they don't often get remarried. And that creates this challenge point of an ex-spouse still being on the beneficiary. And that clause where your current spouse is entitled to the death benefit doesn't trigger any rights.
What about the children? What happens with children from a prior marriage who are named as beneficiaries?
Yeah, so this is a really interesting wrinkle and was in the article that Chris wrote about, which is actually children from a prior marriage being listed in as the beneficiaries. Now, that one makes a lot of sense, right? You got divorced, you change it, you list your kids from the prior marriage, and that really is your intention. Oddly enough, though, it actually the law requires that if they're minor children, or yes, just previous children, to be paid to the step parent in that situation, which creates a whole nother kind of legal and tax potential burden of how should they deal with it at that time. But that's a really interesting wrinkle. So even people who think that they've taken care of this situation by picking somebody else gets, potentially remarried later on. And now we have this step parent issue where they're actually getting paid the money to then pass to those children. And that can create fights, as you imagine. Anytime where the person who thinks they're entitled to the money is not getting the money, this is where we end up in court. They can do a qualified disclaimer and pass it along, then essentially bypassing themselves, having it go to that next beneficiary. But the reality is nobody's required to do that, right? You're that person who's there after you're gone still has to elect it instead of just saying, you know what, this is my money now.
Mhm. Are there any ways to mitigate these issues, such as prenups?
Yeah, so one of the things that Christopher discusses in his article is using prenups. One of the challenges with prenups, though, is actually this notion that most prenups are signed pre-marriage. And that qualified disclaimer essentially of saying, hey, I'm not entitled to these retirement benefits, and that, especially in that children's situation of a prior marriage, is that the prenup is signed pre-marriage. So it doesn't qualify as your spouse actually giving that notice to the retirement plan that they are passing on the death benefits. So there are ways to draft the prenup where you actually execute it kind of, potentially some stuff before marriage and some stuff after you get married. Really, this would require one additional step, which is that after being married, going to the plan and giving that waiver of your death benefit. That's the extra step that's really going to have to occur in that very specific situation because the prenups just don't really cover it. Again, they're state law documents, so they don't supersede anything with ERISA.
All right, well, thank you, Jamie. I mean, it seems like sort of a touchy topic, but I guess it underscores the importance of updating documents, on a divorce to avoid the issue in the first place.
Yeah, I think as the article pointed out, awareness of this is huge. You have to know that it's an issue. Two, you should update your documents as you go. But three, it's understanding that there are even times like where you add your children from a previous marriage where that might not apply if you get remarried and it actually will be entitled to the new spouse. So you have to know even some of those wrinkles to make sure all of this works as your estate is designed.
Right, good point. All right, well, thanks again.